This is Barry Zalma speaking for Zalma on Insurance on YouTube. I am an attorney who has retired from the active practice of law and now spend my time as an insurance claims consultant, an insurance claims expert witness, an author, and producer of these videos. Today, we're going to talk about the Fifth Amendment and the hazard faced by an insured who takes the Fifth Amendment when the insurer asks for an examination under oath. The most effective tool an insurer has against fraud is the examination under oath condition of a first-party property insurance policy. The right to compel an insured to appear for examination under oath and testify has been part of the standard fire policy in every state of the United States that adopted the New York Standard Fire Policy, basically about all 50 states. The right was recognized by the United States Supreme Court in Claflin.v Commonwealth Insurance Company, a decision unchanged since it was rendered in 1888. When an insured is suspected of arson or some other variation of insurance fraud, the insurer will almost always require testimony at examination under oath. The insured often refuses to appear for examination under oath, which of course is a material condition of the policy, claiming that the insurer's demand was a bad faith attempt to deprive the insured of the right against self-incrimination as stated in the Fifth Amendment to the U.S. Constitution. In Grunberg v. Aetna Insurance Company, the California Supreme Court in 1973 ruled that an insured who had stated a cause of action for breach of the covenant of good faith and fair dealing when the insurer denied a claim for refusal to testify at examination under oath. In fact, the insured agreed to testify as soon as the criminal proceedings pending against him was completed. The California Supreme Court, without making any factual determination, allowed the case to proceed to trial since the allegations, which included allegations that the insurer had fraudulently caused the insured to be arrested, and his offer to testify when, shortly after the denial, the criminal charges were dropped, must be assumed to be true because they were ruling on a demurrer, which under the rules of civil procedure requires the court to assume the allegations are true. Grunberg has been applied as if the California Supreme Court stated a hard and fast rule of law that if an insured was charged with a crime, the insurer cannot examine him under oath until the criminal charges are resolved. This has resulted in delays of as much as 5 years. The Massachusetts Supreme Judicial Court was faced with the same question as the California Court and reached a more reasonable result applying the contract language and the law that should be adopted in California, but has not been to date. In Mello versus Hingham Mutual Fire Insurance Company, a 1995 case, followed later by Lorenzo Martinez versus Safety Insurance Company, the court held that the failure of an insured to appear at examination under oath, even while criminal charges of arson were pending, was no excuse, and the suit was barred. The reason for the decision was based on the fact that Hingham issued a policy to the plaintiff effective September 4, 1992, and shortly thereafter, on September 25, 1992, a fire of undetermined origin broke out at the plaintiff's residence. Hingham was informed by the local authorities that the plaintiff was a suspect in a suspicious fire. Hingham, in accordance with the terms of its contract, demanded the examination under oath of its insured. He initially agreed to an examination, postponed it twice, and then refused to testify, asserting the plaintiff's constitutional privilege against self-incrimination. Hingham denied coverage for the fire loss, and plaintiff sued. In reaching its decision, the court noted that it is the law in most jurisdictions that the submission to an examination, if the request is reasonable, is strictly construed as a condition preceding the insurer's liability. The Massachusetts Supreme Judicial Court, finding the privilege did not apply to an examination under oath, stated, quote, "Where the undesirable consequences arise from the claimant's own voluntary actions, the privilege against self-incrimination cannot be used to extricate the claimant from such a dilemma of his own making. The plaintiff voluntarily entered into the contract with Hingham, another private party. Hingham obligated itself to perform duties, some of which were contingent on the plaintiff's actions. The plaintiffs made a claim against Hingham for coverage, and Hingham asked that the plaintiff keep his part of the bargain, even if it may harm his interest in the criminal investigation. A dilemma this may be, but it is not of Hingham's or the Commonwealth's making when an accused must choose between forfeiting the opportunity to speak in his own behalf and subjecting himself to cross-examination. Thus, it is not by the Commonwealth or by Hingham that the plaintiff is compelled to furnish evidence against himself, but by his own contractual undertaking." Close quote. The Massachusetts Supreme Judicial Court also refused to adopt the plaintiff's suggestion that both parties' rights could be protected by delaying the examination under oath until after the criminal proceedings were resolved. The court disposed of the argument succinctly and stated, quote, "The insurer's contractual right is to determine promptly, while the evidence is still fresh, the validity of any loss for which it might become liable. The insurer is under a corresponding duty to pay any claim promptly. In these circumstances, the insurer should not have to delay its investigation for an indeterminate and possibly lengthy period to comport with the interests of the insured." Insureds in California have used the decision in Grunberg as a club against insurers placing the investigation on hold for years while the insured fights against a criminal prosecution. The Fifth Amendment does not bar all testimony. It only requires that no person shall be compelled to accuse or furnish evidence against himself. When a person enters into a contract of insurance, he or she promises to appear and give testimony at examination under oath if the insurer requests it at a reasonable time and place. The insured is not compelled to give testimony. He promised to do so, and if he fails to keep the promise, he has breached a material condition of the policy. As the California Court of Appeal has stated in a leading case called Liberty Mutual versus Altvillich, the presence of the implied covenant as part of all insurance contracts has been increasingly the source of spectacular jury awards based on tort theories such as to enable the imposition of exemplary damages. Quote, "We conclude, therefore, that the duty of good faith and fair dealing on the part of defendant insurance companies is an absolute one. The non-performance by one party of its contractual duties cannot excuse a breach of the duty of good faith and fair dealing by the other party, while the contract between them is in effect and not rescinded." Close quote. Faced with this sweeping and portentous pronouncement on the force and dignity of such covenants, the court found no difficulty in construing the scope of their impact to devolve alike upon the insured as well as the insurer, and that a breach by the insured would lead to the same legal consequences as any garden variety breach of contract. In Fremont Indemnity versus the Superior Court, a 1982 California Court of Appeals decision, the court stated, quote, "Plaintiff here has brought a civil action claiming rights under a fire insurance policy. In so doing, he has placed in issue all factual matters relevant to any exclusion clause in that policy. To reiterate, the gravamen of his lawsuit is so inconsistent with the continued assertion of a privilege as to compel the conclusion that the privilege has in fact been waived. Based upon the foregoing, the court held that the plaintiff's filing of an action to recover on the fire insurance policy operated to waive his constitutional privilege against self-incrimination with reference to any factual issues, particularly as to the applicability of the arson exclusion tendered by the complaint." Of course, there is no arson exclusion. As the court noted, it is the fraud exclusion where one commits arson to defraud the insurer. Regardless, plaintiff finally may claim his privilege, but he will have to dismiss his lawsuit if he persists in doing so. As variously stated in the authorities we have relied upon, the court stated it cannot have his cake and eat it too. So when a plaintiff insured sues the insurer, he cannot claim the privilege against self-incrimination because by merely dismissing his lawsuit, his Fifth Amendment rights are protected. Most of the cases arise in the context of an insured who has filed suit for coverage under an insurance policy but has refused to comply with the insurer's request for an examination under oath. Most involve fire damage coverage and claims of arson. The universal rule in that context is that the insured cannot use the Fifth Amendment on the one hand to avoid the contractual obligation to cooperate with the insurer, and on the other hand, compel the insurer to provide coverage. The majority view is based on the understanding that the compulsion secured by the Constitution is a compulsion exercised by the state in a sovereign capacity in some manner known to the law. To bring a case within the constitutional immunity, it must appear that the compulsion was sought under public process of some kind. It seems the pendulum is swinging. It is time that insureds recognized and insurers enforce the rule of law that requires an insured to appear for examination under oath promptly when required to do so by his insurer as mandated by the standard fire insurance policy. If Grunberg stands for the proposition that insurers must wait until the insured is exonerated in his criminal proceeding, the California Supreme Court should properly revisit Grunberg and adopt the reasoning of the Massachusetts Supreme Court in Mello and the California Court of Appeals in Fremont and Out Village. This video has been adopted from an article in my book, Heads I Win, Tails You Lose, from chapter 39 of that book, which is available from Amazon.com as both a Kindle book and as a paperback. It is chapter 39, Don't Take the Fifth Amendment When Your Insurer Asks for an Examination Under Oath. And if you found this video to be of interest or useful to you, please consider subscribing to my YouTube channel and checking out the book's availability at Amazon.com or at my website Zalma.com by clicking on the link to the Insurance Claims Library.